First, why isn't Mr. Lindquist here?
Well, good question, Judge. I've tried to call him this week and his phone apparently is out of service. So I stopped at Centuria to check to see if he was home here an hour ago. There was nobody home. The street address that's in the court file is spelled wrong, but that was the residence I stopped at. So that's about all I can tell you.
And I can say that there was enough time for proper notice, and the court did send a notice of hearing to Mr. Lindquist and to his address in Centuria. We have not received any return mail. We are in victims' rights compliance. I have victims appearing by telephone conference, or excuse me, Zoom video conference capability. Mr. Schmidt, we're here for a status pursuant to the information you've provided in your letter. I'm not sure if we need to address that, at least at this moment, but I will ask, what is the state requesting?
I do know he's not living in Centuria. When I was prepping my police, one of them mentioned they ran into him and he lives somewhere else and he's somewhere in the county. I don't recall where.
Well, for the record, he is on bond. He has the legal requirement to update the court within 48 hours. We have his Centuria address. We do not have any updated address.
Before a single word is spoken in this courtroom, one thing is already clear. This is not a routine plea hearing. What you're about to watch is a layered courtroom moment involving drug trafficking charges, a last-minute felony bail jumping allegation, and a judge making sure the process is airtight from every legal angle. The defendant, Brandon Allen, walks into court expecting to resolve one case, but suddenly finds himself dealing with two felony matters, one of which his own attorney had just learned about moments before the hearing. And that's where the tension begins. Judge Melissia R. Mogen, calm, precise, and absolutely unyielding when it comes to defendants' rights, immediately slows the entire process down. Why? Because rushing a plea when a defense attorney hasn't reviewed a new charge is a fast track to an appeal. And then there's the deal on the table. One charge dismissed and read in, a pre-sentence investigation that will heavily influence sentencing, and a potential exposure of up to 25 years in prison and a $100,000 fine. But here's the real question. Does the defendant truly understand what he's giving up today? And is this plea being entered freely or under pressure created by stacked charges and limited options? As this hearing unfolds, you'll see how a judge balances efficiency with constitutional safeguards, how plea agreements really work behind the scenes, and why the smallest procedural details can decide someone's future. Watch closely, because every yes, ma'am, carries real consequences.
We will go on the record in the matters 25 CF 98, 25 CF 178, State of Wisconsin versus Brandon Allen. The state appears through Assistant District Attorney Jose Vila in person. We have Mr. Allen appearing in person with counsel Joel Feliski. It says we're set for a plea hearing and an initial appearance. Mr. Feliski, please update the court.
Thank you, Your Honor. I was only just recently informed of the new charge, the new case filed against Mr. Allen. So I'm not sure if we're ready to proceed with the initial today. However, we are ready to proceed with the plea. Mr. Allen has agreed to plead in count 1, 25 CF 98, with count 2 being dismissed and read in. The parties are making a joint recommendation for a PSI to be ordered. The state will be capped at the recommendation of the PSI while the defense remains free to argue. I have a completed plea questionnaire form with me. May I approach?
Just wait 1 second. Mr. Vila, the other matter is a felony bail jump allegation. With that new charge, does the offer still exist?
Yes, Your Honor, the offer is still intact, and we can do with the initial at a later date since Mr. Feliski was unaware previously.
So is this not something that could be contemplated as being a part of this agreement? Do you need time, since Mr. Feliski has never had an opportunity to even review if this existed?
I would defer to the defense of how they want to proceed, but the offer is going to be to dismiss and read in that charge into this global agreement anyway.
So it makes absolutely no sense to waste some time and to set it for another initial. Why don't I just give time? I want Mr. Feliski, since you're just aware of it right now, I am going to print it off unless you have access to it. You have access to it.
This moment right here is more significant than it sounds. When Judge Mogen pauses the hearing to make sure defense counsel has access to the new felony bail jumping charge, she's doing more than being polite. She's protecting the record. If this plea moved forward without the defense having time to review that new allegation, it could later be challenged as ineffective assistance of counsel, which would put the entire conviction at risk. That's why the judge insists on printing the charge, giving counsel time to review it, and confirming that everything is fully understood. Notice how the state confirms the offer still stands. Dismiss and read in, meaning the charge won't result in a separate conviction, but can still be considered at sentencing. That's a key distinction many people miss. So here's the engagement question for you. If you were the defendant, would you move forward today or ask for more time knowing another felony is now part of the equation? This is the courtroom equivalent of choosing certainty over risk, and Judge Mogen makes sure that choice is informed, not rushed.
Do not believe I have access to it, Your Honor. I don't believe like I said, I wasn't aware. I wasn't appointed to this case.
What I'm going to do is I'm going to print this off for you, Mr. Feliski. I'm going to allow you to read it quickly, and then I am going to have you briefly discuss with Mr. Vila the matter, because I want you to do your job and not have any chance of ineffectiveness, and then discuss with him the potential of having this, as he stated, as a possible dismissed and read in, and then talk to Mr. Allen, and then update me and let me know what we're doing here today.
Certainly, Your Honor.
You can come on up and it'll be printed right there. We are adjourned briefly. I have a Debbie. Is the Debbie for the Gerald Lindquist matter? I believe it would be related to a victim. Is that correct?
That is correct.
All right. We are not yet there, obviously, and it actually may be slightly delayed, but I just wanted to let you know that so you can be aware and just hang out, okay?
Okay, thank you. Appreciate it.
Thank you. Thank you. I have in front of me a plea questionnaire waiver of rights form. Mr. Allen, do you recognize the document?
Yes, ma'am.
Did your attorney thoroughly go over this document with you?
Yes.
And he went over it word for word?
Word for word, yes.
And you understand everything completely on this document?
Yes, ma'am.
If by chance you didn't understand something thoroughly, did you ask him to explain it?
Yes.
And he did so.
Yes, ma'am.
So you are telling the court you fully understand everything.
Yes, ma'am.
Is that your signature on the second page?
Yes, it is.
So even though prior to this hearing, the new case 25 CF 178 was not included in the offer and was not included in the offer and the acceptance, nor was it added to the plea questionnaire waiver of rights form. You understand now that it is, and again, you waive any allegations or claims as it relates to Mr. Feliski and his representation with you on that new charge.
Yes, ma'am.
So you're 39 years old. You have 12 years of schooling. You can read, write. You understand the English language. Is that correct?
Yes, ma'am.
You are pleading guilty to possession with intent, methamphetamine greater than 10 grams, but less than 50 grams. Is that correct?
Yes, ma'am.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes, ma'am.
Did your attorney go over with you the maximum possible penalties you face?
Yes, ma'am.
No mental illnesses or disorders, no alcohol, medications, or drugs within the last 24 hours?
No, ma'am.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on this plea questionnaire. Did your attorney thoroughly go over those rights with you?
Yes.
Do you understand them completely?
Yes.
I am going to briefly go over those rights with you again, simply because this is a serious charge of a Class D felony, and I want to ensure that you fully understand those rights, okay?
Yes, ma'am.
Do you understand that you would have the right to a trial? You would have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would also have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you would also have the right to have the state prove your guilt beyond a reasonable doubt.
This is where the gravity of a guilty plea truly lands. Judge Mogen isn't just checking boxes. She is building a bulletproof plea colloquy. Every right is explained. The right to a jury trial, to confront witnesses, to remain silent, and to force the state to prove guilt beyond a reasonable doubt. And listen carefully to the consequences being laid out. A Class D felony here means potential decades behind bars, lifetime firearm restrictions, and the temporary loss of voting rights. This isn't abstract, it's permanent life impact. The judge also makes it crystal clear that no one controls the sentence but the court, not the prosecutor, not the defense, not even the PSI. This moment raises a critical question for viewers. When faced with overwhelming penalties, is a plea truly voluntary, or is it the only realistic option left? Judge Mogen ensures the answer, at least legally, is undeniable.
Do you understand all of those rights you're giving up here today?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
Yes.
You will no longer be able to vote in any election until your civil rights are restored.
Yes.
Did you review the criminal complaint with your attorney?
Yes, ma'am.
And that would be the original charging document and all of the facts that are alleged in that?
Yes.
For the most part, are those facts accurate?
Yes.
The state would have to prove here today that count one, possession with intent to deliver methamphetamine greater than 10 grams but less than 50 grams, that on or around July 10, 2025, you possessed a substance with the intent to deliver a controlled substance, to wit, methamphetamine, again, in an amount of more than 10 grams but less than 50 grams. Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $100,000 or imprisonment of not more than 25 years or both?
Yes.
You understand that?
Yes.
And again, first there's an offer here that is presented by the state and you have accepted, where the court will order a pre-sentence investigation report. The state would be capped at that recommendation in the PSI and the defense would be free to argue. Do you understand what a pre-sentence investigation report is?
Yes.
Do you understand it will contain a whole lot of information about you and your life, and provide a recommendation as to sentencing from the Department of Corrections standpoint?
Yes.
Do you understand I'm not bound to follow that recommendation?
Yes.
I'm not bound to follow the recommendation of the state,
Yes.
and I'm not bound to follow the recommendation of the defense. Do you understand that?
Yes, ma'am.
Do you understand that I am free in my own discretion to sentence you to what I believe is an appropriate sentence based upon all of the facts in this case and all of the information that is provided to me about you? Do you understand that?
Yes, ma'am.
And it could be the maximum possible penalty. Do you understand that?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Now, with regards to that criminal complaint, you did review it thoroughly and you are admitting here today that for the most part, those facts are accurate, correct?
Yes.
And your attorney thoroughly went over those facts with you
Yes.
and you do understand them completely?
Yes.
Are you pleading guilty today of possession with intent to deliver methamphetamine because you are guilty of that charge?
Yes.
And it is and was an amount greater than 10 grams but less than 50 grams?
Yes.
Mr. Feliski, may the court use the probable cause section of the criminal complaint to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you, Mr. Allen, for you to plead guilty to this charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing here today
Yes.
and voluntarily?
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
And he's looked at all of the discovery in 25 CF 98 and discussed it with you?
Yes.
Has he discussed with you the potential for any defenses you could have?
Yes.
Has he discussed with you any potential of a lack of defenses with you?
Yes.
Has he discussed with you that it is yours and your decision alone to make whether or not you proceed to a jury trial?
Yes.
Are you satisfied with his services?
I am. Yes.
Any questions for the court or your attorney before I proceed?
No, ma'am.
Now, with regards to 25 CF 178, you understand that charge of a felony bail jumping allegation
Yes.
on or around December 4th, 2025. It's alleging that as being charged with this previous Burnett County case, 25 CF 98, and you were released from custody, you intentionally failed to comply with the terms of your bond by failing to pass a drug screening test and by using an illegal drug or substance. Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 6 years or both?
Yes.
And do you understand that you would have the right to have a preliminary hearing?
Yes.
And you understand what that hearing is?
Yes.
Did your attorney have the ability to discuss that with you here today?
Yes.
And are you telling the court you wish to waive the right to that preliminary hearing?
Yes.
Do you understand at a preliminary hearing, your attorney would be able to ask questions of the state's witnesses, would be able to call witnesses on your behalf. He would be able to produce evidence on your behalf or possibly discover things about the case, which could include defenses, but you're giving up those rights today?
Yes.
Do you understand that if the state does not meet its burden as to that felony, I could amend it to a misdemeanor or I could dismiss it altogether, but you're giving up that right today?
Yes.
Do you understand that as a result of waiving the right to a preliminary hearing, you would have been given an opportunity to have a trial on this matter?
Yes.
Do you understand that once you give up the right to a preliminary hearing, it is forever and you cannot get it back?
Yes.
Has anyone made any threats or promises to you other than an offer that you've accepted to dismiss and read in this charge? Have they made any threats or promises to you for you to waive your right to a preliminary hearing?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
I will find that you're competent, you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing. I will find probable cause and I do bind that matter over. Information for 25 CF 178.
Thank you, Your Honor. I'm going through and filing the information now. It mirrors that criminal complaint.
He understands charge and maximum penalty and enters a not guilty plea.
Yes, Your Honor.
All of that is done. Not guilty plea is entered on your behalf. Again, you would have had the ability to go to trial. You still can if you tell me you wish to do that, and you would have the right to have a speedy trial on that matter if you desire. Do you understand that?
Yes.
Okay, the not guilty is entered on your behalf. Now, as it relates to the other matter, do you have any questions for the court with your plea or for your attorney before I proceed and ask what your plea is?
No, ma'am.
All right, then count one, possession with intent to deliver methamphetamine greater than 10 but less than 50 grams in 25 CF 98, a class D felony, maximum penalty, $100,000 fine, or 25 years of incarceration, or both. How do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of that count. The other matters will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. The court will order a pre-sentence investigation report, long form. Agent does not need to appear, but should be readily available by telephone in case questions arise. At this time, the court is going to revoke your bond. This is a serious felony. I'm going to set the matter for a sentencing hearing no sooner than 60 days out to give DOC an opportunity to prepare the report. I am pretty open the week of March 23rd. Mr. Flisky, any preference on a day or morning or afternoon?
Your Honor, I have availability all that day, all that week, apart from the 26th. I have a trial in Washburn.
You're arguing, Mr. Vila?
Yes, Your Honor.
I'm just trying to figure how long we may potentially need. 45 minutes, starting at 1.
I believe that's appropriate, Your Honor.
On the 24th. So March 24th, 1 o'clock to 1:45. We will schedule the sentencing in this case. Anything further from the state?
I don't believe so, Your Honor.
Mr. Fliston?
Nothing further. Thank you.
All right, thank you. We will see you on March 24th. Who is the iPhone? You are muted.
It's Christina Fickbaum.
All right, thank you. Okay, Mr. Amon.
Afternoon.
Good afternoon, Mr. Amon. Is it a nice day out?
So far, so good.
I don't get to check how sunny it is a lot of the times. I wish
Well,
this
it
had
was when I
windows.
entered.
Well, that's good. All right. We will go on the record in the matter 24 CF 213, State of Wisconsin versus Gerald Lindquist. The state appears through District Attorney Kevin Schmidt in person. We have Defense Counsel Gregory Amon appearing in person. We do not have Mr. Lindquist. This is a status conference that has been set due to information provided by the state, a letter to this from the state to the court, and we do need to address that. First, why isn't Mr. Lindquist here?
Well, good question, Judge. I've tried to call him this week and his phone apparently is out of service, so I stopped at Centuria to check to see if he was home here an hour ago. There was nobody home. The street address that's in the court file is spelled wrong, but that was the residence I stopped at, so that's about all I can tell you.
And I can say that there was enough time for proper notice, and the court did send a notice of hearing to Mr. Lindquist and to his address in Centuria. We have not received any return mail. We are in victims' rights compliance. I have victims appearing by telephone conference, or excuse me, Zoom video conference capability. Mr. Schmidt, we're here for a status pursuant to the information you've provided in your letter. I'm not sure if we need to address that, at least at this moment, but I will ask, what is the state requesting?
I do know he's not living in Centuria. When I was prepping my police, one of them mentioned they ran into him and he lives somewhere else and he's somewhere in the county. I don't recall where.
Well, for the record, he is on bond. He has the legal requirement to update the court within 48 hours. We have his Centuria address. We do not have any updated address. We did not receive any return mail. The court would get that. It would be put into the electronic file. We have no indication that he is not living at that address. Even if he was not, he again is on bail bond that with the requirement of 48 hours after any move or mailing changes, he must notify the court.
The tone of this courtroom shifts dramatically here. In the Gerald Lindquist matter, we're no longer discussing a plea. We're dealing with absence, uncertainty, and accountability. The defendant is on bond. That means legal obligations. Update your address, keep a working phone number, and show up. When none of that happens, the court is left with one option: protect the integrity of the process. Judge Mogen carefully weighs the facts. Proper notice was sent, no mail was returned, and the defendant failed to appear. That's not speculation, that's record evidence. Yet notice the restraint. Instead of immediately forfeiting bond or assuming intent, the judge pauses, considers possible explanations, and even stays forfeiture. Ask yourself, is this compassion, or a warning shot before consequences escalate?
Well, I would ask for a warrant then, I suppose. The main reason I did my filing is because I was concerned about the possibility we could get to trial and then Gerald Lindquist would show up and say, I don't know the evidence against me. We can't have the trial. I'm trying to avoid that.
I understand your request, but as I see it, there was ample time. This was scheduled on December 29th. There was ample time from the notice to be sent to Mr. Lindquist, and he is not present or appearing today. And I don't have any updated address information.
I know, that's why I requested a warrant.
So,
And
but I'll
Judge-
go to argument for Mr. Amen, but you indicated you have attempted to get a hold of him. And for the record, we have probably the same telephone number you have ending in 3157 and no updated telephone. And by bond requirements, he's supposed to update the court within 48 hours of any change, including not having a working phone.
Just 1 second, Judge. The number I have for him ends in 0454.
0454.
Is that the one you have?
Nope, the court has 715-533-3157.
This is the number I reached him at last time before our final pretrial. He didn't indicate to me that he had a different number. The only other information that I could provide, Judge, is that he hasn't missed any court appearances, much to my surprise, because he's been, I think, on and off homeless status. But there's nothing else that I can add at this point that wouldn't create a problem for my disclosure. But I haven't heard from him and I have tried to reach him. So that's all I can tell you.
Do you want to try the number that the court has? I can give you that ability and then let you be heard on the other information from the state.
Sure.
715-533-3157.
3157. Let me step outside.
All right, we're briefly adjourned.
I just don't feel that that's probably his direct number, unless he's got another one.
Back on the record, same appearances as previously noted. Mr. Alman has had the opportunity to call Mr. Lindquist on the telephone number the court has in its file. He was unable to get a hold of him. It is a working number, but does not have a personal voicemail message. It just has the robot message. So it's unclear whether or not that is Mr. Lindquist's number. Mr. Alman, since we are here for a status, do you have any statement from Mr. Schmidt's letter to the court? Do you want to make any argument or anything with regards to that?
I know what the case is. It's not rocket science. I'm ready to go. We'll be ready to go with or without Mr. Lindquist, or with or without his input. I did want to make a note that the number that I had for him was as of July 7, 2025.
July 7?
Yes. Which you can probably tell how recent that number is.
Yeah, that's not him coming in. Do you have the ability, well, not for the record, do you have the ability to look to see if we've changed the telephone number and when?
It would be, it's usually only address updates that.
Give you notification.
Also, let me check, Judge.
Back on the record. Well, obviously, the court cannot go over anything with Mr. Lindquist to determine whether or not he is aware of the evidence in discovery and has had an opportunity to, or will have an opportunity to thoroughly go over it with his attorney. He is not present here. We do have a speedy trial scheduled for next Thursday and it's not speedy, I believe. It's just a 2-day trial scheduled for Thursday and Friday. Because, am I correct? It is not a speedy request.
It's not a speedy request, no.
So if he isn't in appearance here today, then if the court removes that trial and resets it, it wouldn't be in violation of his speedy right, and any of that, and he can make a speedy demand once he is back in front of the court if he wishes to have this resolved. Ms. Bauer, can I assure that you will speak with the victim or the victim's advocate as it relates to this matter and with regards to their request for disposition? At this time, I'm kind of tied. It's Friday and we have the jury trial scheduled for next Thursday. And I don't have Mr. Lindquist and I need to go over certain things on the record prior to the jury trial. So, Mr. Amen, regardless of if the court issues a warrant, what are your thoughts on moving the jury trial?
I don't have an objection to it. In fact, I will come here regardless of what the court does, warrant wise, trial wise. I will come here next Thursday morning in case he shows up, because he's one of those guys that tends to show up for the hearings and otherwise you never hear from him and you can't reach him. So I suspect that's probably what's going to happen.
Okay, so if that's the case, even still, knowing that you have had a difficult time trying to connect with him and you have the discovery, you say it's not rocket science, but a little later in the timeline of things or whatnot, it would lead me to believe then that he would need an opportunity to sit down with you and to go over the discovery and the evidence anyway, so that he can have his input and he can make those decisions, because it is ultimately his rights and his liberty at stake and his choices to make as it relates to a jury trial. So regardless, the court must remove the jury trial scheduled for January 15th and 16th, because I need to ensure regardless that he has the ability to meet with Mr. Amen and to go over that evidence and discovery and any defenses or lack of defenses and all of those other matters. At least then we can figure out where Mr. Lindquist is, why he's not in court here today. But I will issue a warrant, and Mr. Amen, if you're able to get in contact with Mr. Lindquist and there's something beyond his control or his ability to be able to attend here today, although weather is good, driving was good, you drove from a significant distance away, the court would consider quashing the warrant. However, it appears that he may or may not live at the address that the court has, and that needs to be confirmed as well. So I will issue a warrant for $2,200 additional cash. I will forfeit cash pursuant to 969.13 of the Wisconsin statutes, but I will stay that forfeiture. I will stay the forfeiture because I don't have a reason as to why he's not here today. I don't know if it's cold feet for a trial. I don't know if he wasn't at the residence to get the hearing notice. So I will stay that forfeiture. Regardless, the court is going to set that $2,000 aside for any potential restitution if he is found guilty in any matter or he does enter a plea of guilt. Anything else I'm missing?
No.
Mr. Amen. That sounds fair to me, Judge. You recall that you did question him last time about his desire to continue to go to, to go to trial. And I've thoroughly reviewed with him what I think are the facts of the case, regardless of the discovery. So I think he's pretty well appraised of those things. And that was his decision. He was pretty adamant about it when he was here. So for whatever that's worth, I just wanted to make sure that.
Thank you.
That's
One more
correct.
thing that I will add, that we were here on a final pretrial on December 18th, 2025, in which Mr. Lindquist was in court. And at that time, he did not update the court of any change in address or telephone number. That's just stated for the record. So, all right, there's nothing further, then we are adjourned. Thank you. Ms. Sherwood?
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you. It's a pleasure to see you.
See you soon. Maybe next week. I think I'll come on Thursday anyway in the morning. just to make
Okay,
sure.
and we'll have the days open, so.
Okay. Excuse me.
Good afternoon, Your Honor.
Good afternoon.
Today's courtroom proceedings show exactly how justice unfolds in real life, not through dramatic speeches, but through precision, patience, and process. In State versus Brandon Allen, Judge Melissia R. Mogen accepted a guilty plea only after confirming it was knowing, intelligent, and voluntary, ordered a pre-sentence investigation, revoked bond due to the seriousness of the offense, and set the case on a path towards sentencing where every detail will matter. In State versus Gerald Lindquist, the court balanced defendants' rights with accountability, ultimately issuing a warrant while preserving fairness and due process. These cases remind us that courtroom decisions ripple far beyond the bench, affecting liberty, victims, and public trust in the system. Now we want to hear from you. Who do you think handled their situation better? Should the court have acted sooner in the second case? And if you found this case as compelling as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.